Good evening, everyone. We are actually meeting after a long time. I promise that I'll take more sessions, but somehow I've been busy. It's a difficult time, and I hope everyone is doing well. I hope all of you have taken your vaccinations and are staying safe. We are going to discuss today a topic which is very close to me, and of course, very close to a lot of law students, I'm sure. That is criminal trial, and rather the intricacies of criminal trial. I'll try to tell my practical experiences and share any any such peculiar circumstances that I have come across so that it can be useful to you guys. So without wasting time, we'll just straightforward move to the presentation. So I hope everyone is able to see the screen. Is someone confirm that they can see the screen?
Yes, sir. Yes, sir.
Yes, we can see.
Okay. So the topic today is the intricacies of criminal trial. Before that, we have to first know that when does a criminal trial in fact begin? Uh, because there is a lot of confusion. When does actually the trial begin? Some say that it is usually after the framing of charge. Some say that it is after the cognizance is taken. But I believe that generally after framing of charge, the trial commences. So till so you have to actually distinguish. If someone asks you that distinguish between the time frame of inquiry, investigation, and trial, I have explained it here that before charge sheet, whatever stage that is, that will be investigation, and from the time of filing of charge sheet till framing of charge, whatever the magistrate does, that will be inquiry. So that will actually include cognizance and a lot other steps. And usually after the charge is framed, then the trial begins. And I would really go with this fact that only after the charge is framed, then only the trial begins. It has been narrated in this case called Common Cause versus Union of India, where it has been narrated by the apex court that criminal trial actually commences with framing of charge. In Hardeep Singh versus State of Punjab also, the same has been narrated in a different manner where the Supreme Court actually categorically stated in which kind of cases when does the trial begin, when does the criminal trial begin. That is in sessions cases when the charge is framed under section 228, then only the trial commences. In warrant cases, the charge is framed under 240 or 246 because the warrant cases are divided into two parts, that is cases instituted on police report and cases instituted otherwise than on a police report. So accordingly, whenever the charge is framed as maybe under 240 or 246, then only the uh, trial begins. And in summons cases, here there is no such provision of framing of charge. So when the substance of accusation or the notice that has been the provision has been given, when that is stated to the accused under section 251, then the trial commences. And then I will also discuss in a nutshell all the steps that are actually uh, constituting a criminal trial. Generally, an FIR is lodged under section 154 or a complaint is filed, and then if it is suitable, if the police is of the opinion that then that an arrest is to be made, then he can arrest him, of course after completing all the formalities and making sure that Lalita Kumari case guidelines are followed. Then the production of the accused will be done within 24 hours before the magistrate, because that's a compulsory provision that has been narrated by CRPC. And then remand and custody that can be extended initially for 15 days, and then which can be extended for 60 or 90 days as the case may be, till filing of charge sheet. In our Odisha amendment, it has been increased up to 120 days, which is uh, given under section 167. After that stage is done and dusted, charge sheet is filed under 173. That is, the police actually completes the investigation and files the charge sheet. After that, the cognizance is taken under section 191 of the CRPC, which in fact is the initiation of proceeding. It is not actually the trial commences there. It is the initiation of proceeding because the magistrate actually applies his judicial mind there. And there is of course an exception to that rule, that a second cognizance in sessions case is also taken under section 193. After that step is done, the accused is actually summoned to the court. That is section 204. He is actually summoned to the court, and in the copies of the whatever the police report, the 161 statements, 164 FIR, all the other documents, everything is supplied to the accused under section 207. The reason, of course, we know that he has to know what are the documents on the basis of which the case is framed, so that he can actually meet his defense properly. After that step is done, if it is a sessions tribal case, then the commitment procedure is followed, and the magistrate actually commits the case along with the record and the accused to the sessions court so that the trial can be held there. And if it is not a sessions case and if it is a magistrate tribal case, then depending on the nature of the case and the complainant, when I'm saying the nature of the case of the complainant, that means if it is a summons case, the procedure will be different. If it is a warrant case, the procedure will be different. If the complainant, that means the person who has actually initiated the case, if it is initiated on a police report, then the procedure will be different. If it is a private person or any public body such as municipality or forest authority, and then in that case the procedure will be different. Whatever, then the magistrate actually decides which mode of trial he has to follow. After he decides that, then the framing of charge is done, or the substantive accusation, as the case may be, because as we studied that in summons case, the substance of accusation is actually narrated, and then the prosecution evidence is done. That is, the prosecution is asked to actually narrate his case and bring forward his witnesses and establish the fact of the accused committing the crime. After that step is done, the accused statement is done. That is another step which has been inserted by CRPC to make sure that the accused has the opportunity to know and respond to the incriminating circumstances. That is 313 CRPC. After that step is done, usually the defense evidence is done. That is, defense or the accused is actually asked to bring forward his evidence and bring forward his witnesses. After that, a final argument usually is done, though it is not mentioned categorically in CRPC. One final argument is done practically, that is to summarize all the steps, all the things that have been done by both the parties, and then usually the judgment is pronounced. This is in a nutshell all the steps of the trial, and then we'll discuss the kinds of trials. I believe we have discussed already the trial of trial of sessions cases. So for now I'll skip that. If it is necessary, I'll probably discuss it in a nutshell, but then for now we'll skip that. So I'll start with trial of summons cases, which is enumerated in chapter 20 of CRPC. It says that so before that we have to know that what is a summons case. Summons case is a case which is not a warrant case, and what is a warrant case? That has been given under section 2X. That is any case where the offences are prescribed with the punishment of death, life imprisonment, or an imprisonment exceeding 2 years. In such case, it shall be held as a warrant case. And in only warrant cases, there shall be a trial of warrant cases, trial of warrant cases. But in all other cases which are not warrant cases, then a trial of summons cases shall be done. So section 251 says that when the accused is actually brought or he appears before the court. So we have to know one thing, that when the actually summons is issued to the accused, he can either, if he is in bail, then summons will be issued and he will be he'll be appearing before the court, and if he's in jail, then he'll be brought by virtue of a production warrant. He'll be brought before the court so that the substance of accusation will be stated. And of course, in this case, he can appear through the pleader if section 205 has already been allowed. But you have to remember that in only in summons cases and summary cases, of course, the accused can appear through pleader, but not in warrant cases. In warrant cases, the accused cannot actually appear through pleader unless there is a special circumstance. I'll discuss that as well. And once he is brought or appears before the court, then the substance of accusation, which is the alternative of charge, because charge is not being framed here. So basically, the accusation, whatever it is there in a substance, in a nutshell, it will be stated to the accused so that he'll again know the circumstances under which this case has been filed against him. Then he'll be asked whether he pleads guilty or not. And of course, you have to remember that framing of charge is not compulsory, unlike warrant cases. In summons cases, obviously you don't have to frame charge, and you can go ahead with the substance of accusation. Of course, it's a less formal case, so you have to skip certain steps to make sure that the trial is quicker. Section 254(2) again says that if the accused pleads guilty, then the magistrate can convict and sentence him as per his discretion, or can go ahead with the trial too. That means when the accused pleads guilty, then that doesn't mean that the magistrate has to necessarily convict him. You'll obviously think that you'll be thinking that why is it that the magistrate doesn't have to necessarily convict, because he is admitting himself. We can straightforward go with the conviction. That will save a lot of time and money of the state. But then the magistrate has to satisfy that it is a voluntary pleading guilty, and the fact that he's not under any pressure or he's not biased or anything. Then if he is convinced, then he can go ahead and convict and sentence him. If not, then he can go ahead with the trial. There is also another proviso which is given here, that one accused cannot plead guilty on behalf of the another. As in, if I come, then I will only say that I have committed this offense. I cannot say that I and Ram have both committed this offense. I can't say that. Now comes section 253, which is saying that in petty cases, which has been enumerated in section 206 of CRPC, if summons is issued and the accused wants, then he does not have to come to the court, and he can actually appear through the pleader or send fine through the messenger, accepting the charge or accepting the accusation that has been leveled against him, and the magistrate can very well accept the fine and convict him, and then just dispose of the case accordingly. Section 254 says that what if he doesn't plead guilty? So we came from the fact that he actually substantive accusation was stated, and then if he pleads guilty, then he can be either convicted and sentenced or can go ahead with the trial. In petty cases also, the more manner in which it can be disposed, that we discussed. And then what if he doesn't plead guilty, or if he pleads guilty and the magistrate thinks that still then I will go ahead with the trial, then the court will hear the prosecution and take evidences and witnesses. Then he'll hear the prosecution and take evidences. Then after that, he'll hear the accused and take evidence. After the prosecution, then the accused evidence will be taken. And then he can summon any witness if given an application by both the parties and the court thinks that it is necessary. Of course, if the accused wants to summon any witness, then fees can also be asked from him. We also have to note here that 313, that is the accused statement, that is optional here. So basically the court does not have to necessarily go ahead with the accused statement. A section 281 memo of substance of accusation that is narrated to the accused. If you read 281, you will know that there only a substantive accusation can be narrated to the accused, and that will be sufficing the cause. here in summons case, this 281 provision can also be followed. Then comes 255, that is after the evidence is taken from both the sides. Of course, the accused statement is done, and then only the defense evidence has been taken. Accused statement is not being compulsorily done here, so 281 can also be done. In that case, 255, after evidence, if he is found not guilty, then the court can record reasons and acquit the accused. And if he is finding him guilty and he is not sending the case under section 325, that is, section 325 says that when the magistrate is not empowered to punish adequately for an offense, he can send the same to the CJM, Chief Judicial Magistrate, so that it can be punished accordingly. If he is not sending the same under section 325, then he can convict and punish the accused. Now comes section 256, which says that if summons is issued on complaint and on the day of the appearance of the accused, the complainant does not appear or has died. So this is a peculiar circumstance. It happens. It usually happens that is that a complainant actually files a case, and if it is a summons case, that means it's a less serious offense. And then the complainant loses interest and he does not actually follow up the case. In such case, the court can very well acquit the accused, and alternatively, of course, he can grant time. The court can grant time or dispense personal appearance of the complainant and still go ahead with the trial if he thinks fit. But then generally it is the provision to make sure that the complainant is serious about the case and he follows up the case so that the trial is carried away without any glitch very promptly. 257 section says that complainant can withdraw the case that he has filed before the judgment with permission of the court. He can do that. Of course, it is a summons case, so less serious in nature, so we don't have to go into the fact that whether it is a compoundable offense or anything. So complainant can withdraw before the judgment with permission of the court. Then again, section 258 says that power to stop proceeding in certain cases, that if summons case is instituted otherwise than on a complaint. So we were discussing the cases where summons case is instituted on a complaint. Now we'll discuss otherwise than on a complaint. Then a JMFC or other may, after recording reasons, can stop the proceeding without pronouncing the judgment. And if principal witness is examined already, then he can acquit the accused. And if he is not examined, then release the accused, and such release shall have an effect of discharge. So this provision is only to make sure that any vexatious claim or any stage the magistrate or the court is of the view that this proceeding is not to be run for the interest of justice, then he can stop it. And if the principal witness on the basis of which the case was to be decided, if he has been examined already, then he has to acquit him, because we know that then again we have to know that discharge and acquittal, there is a prime difference between the discharge and acquittal. That is, once the charge is framed and then the accused is let go of, and then that becomes an acquittal. But before the charge is framed, then if the accused is released, then that shall be treated as a discharge, because the accused has not been charged, so he will be discharged. If once he is charged, then there is no way to discharge him again. So there is only one way possible, that is, you can either convict him or acquittal. Those are the two ways. Of course, if there is any such order that he is acquitted, then under section 378 the prosecution can file an appeal, and if he is released, which will be in the form of a discharge, then a revision can be filed under section 397. And then comes section 259, that is power of court to convert summons case into warrant cases. Power of court to convert summons cases into warrant cases says that during trial of an offense punishable with 6 months or upwards, if according to the magistrate the offense should be tried in a warrant mode for the interest of justice, then he can very well do so. That means the magistrate is actually conducting a case in a summons case, but during the trial at any stage he is of the view that no, this is a case fit to be tried in a warrant mode because the in, interest of justice demands so, then the magistrate can very well do so because for obviously after recording reasons he can do that, and the magistrate may proceed to rehear the case in warrant mode and recall and re-examine the witnesses as well. So he can, if he converts the same into a warrant trial, then he can rehear the case and then he can recall and re-examine the witnesses as well. Now we'll discuss the trial in warrant cases, that is chapter 19. Chapter 19 is divided in again in two subsections. That is, one is when a case is instituted on police report, the trial procedure is different. Even if it is a warrant case, the trial procedure is different. If it is instituted on police report and if it is instituted otherwise than on a police report, then also the trial procedure is different. I had mentioned earlier that according to the, always remember that the trial procedure will differ according to the nature of the case, according to the nature of the complaint. So if the police report, the trial is, the case has come to the court, then the trial will be different. If the private complaint is there, or a public body or a municipal corporation or a forest authority has filed the complaint, then that trial will be different. So we'll first discuss the cases instituted on police report. Of course, the charge, of course, summoning will be done. The accused will be first summoned. If he is outside of the jail, that is, he is on bail, and if he is not, then he'll be, again, a production warrant will be issued and he'll be brought before the court from the jail and produced. And section 238 says that compliance with section 207, that is, when an accused is brought or is brought before the court, or he appears himself because he received a summons, then the magistrate has to satisfy that section 207 has been complied. Of course, this is another check to make sure that the accused's rights are not violated, because this is a more serious nature of offense that has been alleged against the accused. So section 207 says that supply of free copy of police report, FIR, 161 statements, 164 statements, and other documents. These are to be supplied to the accused. Of course, 161 statements, which are 161 statements, if police marks them that they should be excluded and not given to the accused for a specific reason, and the magistrate also agrees to them, then that can be excluded. Of course, that can be supplied later, which has been mentioned in a proviso. Also, other documents, what do you mean by other documents here? There can be any document. If you rely on any document to prove that a 420 has been committed, that is a land papers or agreement papers or anything of that sort, then other documents can also be supplied. But of course, if it is voluminous, then only inspecting rights can be allowed. This is a peculiar provision, again, just to make sure that the burden on the state will be less, because free copy will be supplied. So that's why if it is a 1000-page document, of course it will be very burdensome on the court and the state itself to supply that free copy. So an inspecting right will be allowed. So the accused or the pleader can, on the day of the case, can very well inspect the record, which is in contravention to the general rule that the record cannot be inspected by the accused. But then again, practically, if I speak, then all the time the pleader of the accused and the accused always inspect the record, even if inspecting rights are allowed or not. They always inspect the record. They always go through the record. And as a court, you cannot do anything. And though you can, but then it's better not to, because it will just create disturb the balance. That's all. So the reason of free supply of copy of all the papers is that, as I discussed, that it will be giving an opportunity to the accused to be aware of the case and prepare his defense accordingly. As I'm again stating that the general rule is that the personal attendance of the accused is mandatory. In a trial of a warrant case where it is instituted on a police report, or otherwise than a police report, also personal attendance of the accused is mandatory during all the stages of the trial, unlike in a summons case where it can be actually excused. Now coming to section 239, which says that discharge of the accused. So considering the police report and other documents, whatever documents are there, and then examining the accused and hearing the prosecution and the accused, if the magistrate is of the opinion that there is no ground to proceed, then he can discharge the accused, of course, after recording the reasons. This is an important step that has been mentioned in CRPC to make sure that no false claims or the accused is not harassed unnecessarily. So if there is no ground to on the bare perusal, the general rule is that whatever has been mentioned by the Apex Code also, that the bare rule is that only from the record that has been brought by the police, that is the police report, if the bare perusal of it, and you ask the accused and the prosecution and the accused both, if the court is of the opinion in that there is no ground whatsoever to proceed with the case against the accused, then he can discharge. But if it is not of the opinion that he should be discharged, then he can go ahead with the charge. In this case, Kanti Bhadra Saha versus State of West Bengal, it has been narrated, it has been stated by the Supreme Court that if the accused is not being discharged, then reasons need not be recorded. So if he is being discharged, then reasons has to be recorded. Reasons have to be recorded. But then if he is not being discharged, then reasons need not be recorded. Now coming to section 240, which says about framing of charge. It says that if there is a presumption which is arising in front of the magistrate that there is a ground for proceeding against the accused, of course, after going to the police paper and everything that we mentioned previously, and the magistrate is also satisfying himself that he is empowered enough to try and punish them accordingly, punish them adequately. Adequately. So that means if the magistrate's power is 3 years, punishment power is 3 years, and the warrant case which has come before him can be punished with 7 years or more, then in that case he then he can send the same to the CJ. But if he is not doing that, then he can, or if it is a sessions case, then he can commit the same. Then he can frame the charge in writing and read and explain it to the accused, and then he shall be asked whether he pleads guilty. Now section 241 comes, which says that if he pleads guilty, then the magistrate, as per his discretion, can convict and punish. You must be noticing this, as per his discretion, which is very crucial, because the magistrate has to eliminate all the other possibilities that the accused is doing so voluntarily, as I mentioned. I'm saying this at the cost of repetition, because you have to know, when you study law, when you read law, it should be like you know it. Why does the legislature intend to insert this provision? Because I'm sure all the words that have been, of course, I have not used all the word. I have only used my language so that it will be easier for you to understand. But then once the legislature uses a word, he means it. He means it. He swears by it. They have actually thoroughly discussed it again and again, and they know why they are using it. So when they're using it as per his discretion, that means they mean it. They tend to tell you this, that the magistrate has to satisfy that it is a voluntary one. Again, coming to section 242, that if he does not plead guilty, then the court shall go ahead and hear the prosecution and then take evidences, and then also allow the witnesses, and then fix date and examine them. Of course, if the 161 statements are not there, then generally a witness cannot be called. So 161 statement has to be there, and it has to be supplied to the accused in advance, and then he can be allowed to be made a witness. Of course, additional witnesses can be done even if no 161 statement is there. But if 161 statement is there, then it has to be supplied to the accused first, and then the witnesses can be examined. Here, one proviso is that the cross-examination can be deferred until all the witnesses are examined. Another step, which not necessarily is given in the CRPC in the order, but then accused statement has to be done. Once the prosecution completes the evidence, the rule is that the accused statement will be done. Once the accused statement will be done, then comes section 243. That means the defense witnesses shall come into picture and they will be allowed. But of course, they can be disallowed in a certain case, that is, if it is vexatious or with the interest of delaying the trial or wasting time of the court. And then the magistrate can record reason and disallow the same. But magistrate has to disallow or has to reject such an application if cross-examination has been done before and chance of cross-examination was there with the accused or the defense, but he chose not to. Then in that case, he has to disallow. Of course, after recording reasons, he can allow the same. So there are two contradicting provisos here, that defense will be allowed, then when it will be disallowed, when it is vexatious or with the interest of delaying the trial or wasting time of the court, then it can be disallowed. And if cross-examination has been done or chance of cross-examination was there with the accused but he chose not to, then it will be disallowed, subject to condition that it can be allowed with reasons. Of course, the written statements, if any furnished by the accused, that has to be attached in the record, and expenses whatever of the witnesses, that have to be borne by the accused. Now comes the argument. After the defense is closed, argument is done, and then the conclusion of the trial, acquittal or conviction will be done. If found not guilty, then he can be acquitted. If, of course, I'm mentioning it again that if only charge is framed, then will be acquitted. If charge was not framed, then that would have been different, because he would have been discharged or otherwise. If finds guilty and he does not proceed with section 325 or 360 CRPC, then hearing on the question of sentence will be done, and then the magistrate can sentence him. Of course, in Odisha, section 360 CRPC is not there because there is a specific act, that is Probation of Offenders Act, which is replaced. You can replace it here. You can read it like section 325, or the Probation of Offenders Act is not followed. Then he can hear on the question of sentence. All over India, wherever there is no provision of Probation of Offenders Act, then in that case 360 CRPC is there. Another important thing that you have to remember is that if previous conviction is charged under section 2117, 211 says that charge, it says about charge, and 211 clause 7 says about previous conviction if charged, and the accused is actually denying such allegation, then the magistrate at this stage has to take an evidence on the question of previous conviction, whether actually previous conviction was there, because you have alleged that and the accused is denying that. Then again, and the hearing will be done whether in such and such case he was previously convicted. So the prosecution will furnish the documents that yes, these are the documents which show that he has been convicted, and the accused again will show that no, I had appealed against it and was acquitted therein. So he can show it again. Another thing you have to notice is that previous conviction can only be raised only when conviction is done. I had mentioned this when we were discussing Sessions trial. There is also a reason. Please, someone if knows the reason why this question of previous conviction should only be raised only when the conviction in this instance is done. You please answer me at the end of the session that why is it this provision there that only a previous conviction question can be raised only when the conviction at this instance is done, and then only a previous conviction question can be raised. So then this comes to the second part of the warrant trial, that is cases instituted otherwise than on a police report. So section 244 says that evidence for prosecution. This is a very peculiar case again, because this is the only instance you'll find where evidence will be recorded pre-charge. So before actually filing of charge, evidences will be recorded. The reason being, a complaint is brought by a complainant. The magistrate actually, whatever, after recording the initial statement or 200, 201, 202, he actually takes a cognizance of the offense, but he is not thorough with the case. He does not yet know about the veracity. He's not yet completely sure about the veracity of the allegation or how far it can go on to establish the guilt of the accused. Is completely not sure of the fact yet. That is the reason this provision is there, so that the evidence will be recorded, so that the magistrate will acquaint himself. Also it will bring a lot of clarity to the case, that whether actually a conviction can be warranted. In that case only, he'll proceed with the charge. If unrebutted whether it can be warranting a conviction, then only he shall proceed with the charge. So when the accused appears is brought, then the prosecution shall be heard, and examination of witnesses shall be done, and production of documents shall be done. As I mentioned, it is the only instance where pre-charge evidence is recorded. In a case, Gopal Krishna versus State of Kerala, 2002, it was given that trial in warrant cases instituted otherwise than on a police report does not start until evidence under section 244 is recorded. So we have to remember here that though it talks about evidence for prosecution, so you may be confused that, see, evidence for prosecution has started, so that means a trial has already commenced. But if you keep this in mind, the general rule that trial cannot start until charge is not framed. Till now, charge has not been framed. Though evidence has begun, charge has not been framed. So Supreme Court has also narrated the same in 2002 case, that trial of warrant cases instituted otherwise than on a police report does not start until evidence under section 244 is recorded. A.K. Ghosh, Ajay Kumar Ghosh versus State of Jharkhand, 2009 case, in which Supreme Court has also mentioned that trial court cannot proceed to frame charge until section 244 is carried out. And if he does so, that will be an illegal order, because he has not completely acquainted himself with the facts of the case and still he is proceeding with the charge. That means it will be an illegal order. Section 245 says that discharge. After 244, if the magistrate finds no ground, and as it stands, whatever the evidence has come, if they are to be unrebutted, then if they can't warrant a conviction, 244 says that many evidences will be taken. Whatever evidences have come now, if they stand alone and they are not rebutted, if they can't warrant a conviction, then in that case the magistrate can discharge. Of course, the second subsection says that the magistrate can very well discharge at any stage of the case, any stage of the trial, and he does not have to necessarily follow the procedure of subsection 1. 246 is framing of charge, that if there is a presumption with the magistrate that there is a ground for proceeding against the accused, of course, after going through the section 244, that is the recording the evidences, and the magistrate is empowered enough to try and adequately punish. That means, again, 325 must not be coming into picture, that he does not have to send the same to the CJM, or commitment procedure he does not have to follow because it is exclusively tribal by court of session. Then he shall frame charge in writing and read and explain it to the accused. He will frame the charge in writing and then explain it to the accused, and then he'll be asked if he pleads guilty. He'll be asked if he pleads guilty, and if he says that yes, I plead guilty, then he can be convicted and punished as per his discretion. And if he is not pleading guilty, then he can cross-examine any witness examined previously. So this 246 actually says about a lot of things. It has actually mentioned about the framing of charge. Then he'll be asked about whether he pleads guilty. If yes, then he'll be convicted. And if he is not pleading guilty, then he can be given a chance of cross-examining any witnesses that have been examined under section 244. Of course, re-examination can be done. That means any witnesses which have been cross-examined now, they can be re-examined again. And then additional witnesses can also be taken forward by the prosecution. And after all this is done, then 247, 250, I have by mistakenly I have inserted it here. We'll read it later. 247 says that when the accused, uh, then the accused shall enter defense. Of course, 313 will be there. Accused statement I mentioned, 313 will be there. After that, the defense evidence will come, and the accused can actually come and examine any witnesses. And all the provisions of 243 that we had mentioned previously, that is, uh, all the provisions of 243, that is, if it is a vexatious claim, if it is with the interest of dealing the trial, if it is wasting time of the court, or if the witnesses are cross-examined already, or there was a chance of cross-examination but the accused actually did not avail, so then all these formalities can be followed. Now comes then we'll be doing the argument. The argument stage will come. All the whatever the summary of all the allegations that have been put forward by the prosecution, they'll be stated. The defense will again rebut all the same. There will be 1-2 rounds of rebuttal, and after that, the magistrate can go ahead with the acquittal or conviction. We had studied that previously. This is in similar line, so it will be done. And if in absence of a complainant on the date fixed of hearing, and the offense is a compoundable and a not cognizable one, then the accused can be discharged. So it is saying that if it is the case is instituted otherwise than on a police report, and the complainant is absent on the date fixed for hearing, then the offenses alleged are compoundable and not cognizable nature, then the accused can be discharged after recording reasons by the magistrate. 250 is another provision, is that if there is a vexatious allegation, if the accusation has been done without a reasonable cause, then the court will ask for a show cause, and if it is not satisfied that there was a reasonable cause, then fine can be imposed, and in default 30 days of imprisonment can be imposed. Of course, that can be adjusted in civil suit if there is any between the parties, and if there is a order of fine, there is an order of fine of more than value of more than 100 rupees, then it can be appealed by the person who has been fined as well. Again, we had studied section 237, if I'm remembering correctly. 237 of Sessions Trial also says a similar provision. So this also mentions that this provision shall apply both to summons case and warrant cases as well. So this 250 summarizes this. Now comes the chapter 21, that is summary trial. Please remember that it is not very important for your examination purpose, specifically for mains examination if you are preparing for judiciary. And if not, you have to still know and learn this, because it can come in preliminary. It can come very handy in preliminary. So section 260 to 265, this is a quick trial, so not an ordinary trial, of course. 260 says that power to try summarily, that is there with CJM or Metropolitan Magistrate or Judicial Magistrate First Class, if specifically empowered by High Court. So 461M again says that if not empowered and still tries summarily, then it can be declared void. So if all these magistrates, they think fit that this is the case to be tried summarily, in which cases offenses not punishable with death, not punishable with imprisonment for life, not punishable with imprisonment for 2 years or more. So in all these summons cases, if they think that this is a fit case to be tried summarily, then without following the summons case trial mode also, they can follow a summary trial. Exception to the rule is that section 379, even though it prescribes a period of punishment of 3 years, if the value of stolen property does not exceed 2,000 rupees, then it can still be tried summarily. And of course, as we mentioned that during the summons trial also, it can be converted to a warrant case. So in this type of cases also, in a summary trial when it is going on, and the magistrate is of the view that it shouldn't be tried summarily, then it can either be tried in a summons trial mode or a warrant trial mode, and they can be tried accordingly. 261 says that JMSC also can go ahead with the summary trial if it is specifically empowered by the High Court, but of course with an offence which is punishable only with fine or punishment not exceeding 6 months or attempt or abatement of the same. 262 says that procedure for summary trial, that is procedure of summons trial, can be followed. As I mentioned, that you must be noticing that similar type of cases are being followed, so same procedure will be followed. In case of conviction for substantive offense, not more than 3 months imprisonment can be awarded. So uh, and in lieu of fine, extra imprisonment can also be awarded. It's not very crucial. You just have to remember all of this. 263 is a record in summary trial, so whatever has to be mentioned that has been given. 264 says that judgment, how is that to be written, it is to be recorded in brief. That is it. 265 says that it will be signed by the court. Now we'll discuss other provisions which are very important uh, and actually come under criminal trial, though they have not been specifically categorized under all the heads that we discussed. That is 311 CRPC. That is a very peculiar provision which is always resorted to by both the parties, that recall of the witnesses. In the interest of justice, of course, if one of the party desires to recall a witness, even though he has been examined, re-examined, or cross-examined, then also he can be recalled and examined, re-examined, and cross-examined. Of course, it should be necessary and it shouldn't be only with the intention of delaying the trial, or it should not be vexatious. Another provision which is often coming under trial is section 91 CRPC, that is documents which are not in possession of a party, but they are still necessary to arrive at the truth, and they are very necessary for the just disposal of the case. In such a case also, this provision is resorted to by the parties. Electronic evidence, after the electronic era has come and all the we have completely been dependent upon electronic form of communication. This is also being resorted to. In that case, section 65B Indian Evidence Act certificate is a must. And another provision is section 285 CRPC, that is evidence can also be taken through commission. That is, if the court cannot reach a particular place, so if a patient is bedridden and he cannot be brought to the court, then the court cannot obviously go to the patient's house and examine. I mean, in presence of him, it cannot be done. So he can formulate a commission for that regard, and the commission will go and act as the court on behalf of the court and take the evidence of that bedridden person and then come back and submit a report, and the court shall admit the same as a evidence, which is obviously a special rule, and not in all cases it will be allowed, because the general rule is that there shall be a court, there shall be a prosecution, there shall be the accused, there shall be the witness, and he shall cross-examine, and the court will interfere, and all of that will happen. If it is not happening, then obviously there will be doubts cast on the justice system. So it is sparingly used. Then 296 CRPC is also of a great importance, especially after NI cases have come, because previously there was no such general rule that affidavits will be allowed, but then NI cases have made sure that affidavits will be allowed, and in certain cases also, in criminal cases, the affidavits can be allowed. So these are the provisions that we discussed, and this summarizes in a nutshell the intricacies of trial. If anyone has any doubt, they can go ahead with the same, and then probably I'll ask a few questions. I have a doubt. I have certain doubts. So if there are any questions, has anyone typed anything? I haven't seen. No. If there is any question, you can unmute yourself and just ask them one by one.
Before asking the question, you heard asked that about the object of the previous conviction. Why it is being, means the evidence is being taken after the conviction. I want to answer that probably because the rule has been made to protect the right of the accused, maybe his right of a free trial will be prejudiced if it will come in an early stage and the judge may get biased during his trial. Probably that is the answer in my opinion.
Absolutely, absolutely. A previous conviction, if we previously say before the trial is commencing that he has been convicted on previous occasions, that will create a biasness in the atmosphere of the court, not only in the mind of the judge, but everyone will be of the view that yes, he has committed such an offense before. Probably he has committed this offense now. So better to keep it for later after the conviction in this uh, instant case has been done. Then only we'll go to the previous conviction and other things. Any other question? I want it to be as interactive as possible. It shouldn't be a one-way flow in any manner. If it is, then it wouldn't be fruitful at all. I'm sure. I hope that I was able to uh, narrate or explain to you all the intricacies of criminal trial, though many practical experiences arise, and I wish I could share with you all, but then there are constraints, so I can't discuss them. But then, if you have any doubts, please fire them. Otherwise, I'll ask a few questions. I've actually typed it, so we'll discuss them. Okay, I'll ask the question. That is, does the burden of proof ever shift in a criminal case? Uh, Anyone can unmute. It'll be quick. So we'll do five questions. So does burden of proof ever shift in a criminal case? My question is that. Who will answer this? I hope everyone is knowing what is a burden of proof. Yes, I am sure everyone knows it. What is the difference between burden of proof and onus?
Burden of the proof is shifted, but onus of the proof is not shifted. Uh,
I believe you said the ma'am. You probably mistook it and said the opposite thing. Burden of proof remains constant, but the onus changes. Onus changes. Onus is like a racket. Once I hit it, it will be going to the other court, and then he has to hit it back. The burden of proof is the initial burden, who has to establish that this is the contour of the case. This is probably bringing the fact that the accused has committed the offense. So this is the burden of proof, and onus is the other way. So please tell me that, can there be, ma'am, whoever you answered, you were right. So please answer whether burden of proof can actually shift.
Yes.
No, burden of
In
proofs cannot be shifted, but the onus of proof can be shifted.
Asif sir, you please answer. You please tell me
Burden
in
of
which
proof,
cases in which cases burden of proof can be shifted,
burden of proof cannot be shifted.
cannot be shifted, right? Right.
Just like the prosecution case, prosecution is bound to prove the case beyond reasonable doubt. That liability cannot be that
Okay.
cannot be
I'll give you an
shifted.
example. I'll give you an example. 304B. 304B. Dowry death is 304B, right?
Yes.
There is this other way presumption that the accused has to now establish that whether how he has not committed the dowry death. So what do you think? Here the burden of proof is with the prosecution or with the accused?
Sir,
Initial burden of. Yes, who is it? Umya?
initially, the burden of proof is on the accused, because the judge from the starting presumes that the accused has committed the offense.
Hmm.
Then, if the accused is failing to prove that he hasn't committed, then only it shifts to the other opposite party.
Absolutely, but then that is the reason I asked this question. That Asif, whatever you answered, you couldn't substantiate, but then it is actually right that burden of proof cannot be changing at any cost. Why? I'll tell you. Even though 304B says that there is this presumption will be drawn against the accused and the accused has to prove, still it will not be considered burden of proof, because the burden of proof will be the contour of the case. Now, there has to be an allegation. There has to be some substance which will form the contour or the outline or the sideline of the case. It, obviously, he doesn't have to substantiate the allegation at the go, but then the initial burden, that is always with the prosecution. Even there are hundreds of exceptions, like will term epidemic, this the present epidemic act, under which the persons are booked if they violate certain rules and spread coronavirus. And in such cases also, there is this rule that the burden of proof will be on the accused, that how he has not committed the offense. But then I really am of the opinion, and also I have studied in various Supreme Court cases. I'll supply you the cases where Supreme Court has categorically stated that the burden of proof is always on the prosecution, because that is the initial thing that has to be proved by the prosecution, and then only the accused will go ahead and try to disprove that or prove that or whatever it is. I hope everyone is clear. I'll go ahead with the second question. That is, what is the maximum period an accused can be remanded to the interchangeable custody before the charge sheet is filed under any Indian law? I'll read out the question again because it's a long question. That what is the maximum period an accused can be remanded to the interchangeable custody? Interchangeable means judicial oblique police custody before the charge sheet is filed under any Indian law. Can anyone tell me?
But in
Yes, yes,
Odisha,
Asif.
the maximum period is 120 days. If the offense is punishable with death or imprisonment for life or more than 10 years, and in any other cases, it is 60 days. And apart from Odisha, it is 90 days in case of death or imprisonment for life, for judicial
That
custody.
that is absolutely right. But I again ask this question because this can be a very uh, uh, clever question, because there is this provision, I mean, specific act called Unlawful Activities Prevention Act, UAPA. There, the remand period can go up to 180 days till filing of charge sheet. That can go up to 180 days. When I asked that question, that under any Indian law, I meant if you know about UAPA, you'll be able to answer that the initial remand, unlike in other laws where it is 15 days, it can go up to 30 days, and the total period can be going up to 180 days instead of 120 days, as Asif mentioned correctly, in Odisha, and 90 days in all other states. It can go up to 180 days. And then there will be a third question, that can a warrant case be tried in any other mode? This is a straight question from the topics that we discussed right now. That can a warrant case be tried in any other mode? Anyone
Yes.
Yes, sir.
who said yes? Please substantiate the answer. Asif, you have answered enough. So another ma'am said it. So please substantiate the answer. Who said it?
In summary trial, a warrant case may be tried in summarily.
In summary trial, warrant case may be tried summarily.
Yes, sir.
Anyone else wants to differ? Okay, to answer that, it will be uh, again, as I discussed in summary trial itself, that it should be less than 2 years, and not imprisonment, not punishable with life imprisonment or death. Then only it can be tried summarily. So warrant cases means the cases which are punishable with life, death, or 2 years and upwards. So that means they cannot be tried summarily. Warrant case cannot be tried summarily. So uh, uh, there is specific provisions which say that summary cases can be tried in summons mode or warrant mode. Summons cases can be tried in warrant mode, but warrant cases cannot be tried in summons mode. If it is done, it will be an illegal trial, and it will actually uh, be prejudiced, because all the provision is there for warrant trial, that is to make sure that many checks and balances will be given, one, because the offenses alleged are very serious in nature. So there will be police paper, there will be accused statement, there will be other circumstances like evidence before charge. All the things are done just to make sure that the accused is getting extra steps, to make sure that he is not being uh, prejudiced. So that is the reason warrant cases, or the cases which are to be tried in warrant mode, they cannot be tried in any other mode. But the vice versa is possible. So summons case can be tried in a warrant mode. Summary case can be tried in a summons mode or warrant mode, both. But warrant case cannot be tried in any other mode. Another question:
Sir,
can an
sir,
accused? Yes, yes, please, please. Who
sir,
is it?
I like to read one sentence.
Yes,
It is written in the book. In summary trial, all cases shall be tried according to the procedure for the trial of summon case, whether the case is summon case or a warrant case.
what is it written?
In summary trial, all the
Hmm.
cases shall be tried according to the procedure for the trial of summon cases. The procedure is summon cases, whether the case is a summon case or a warrant case.
Okay, so where are you reading it from?
This book is CRPC Paranjape.
Paranjali, please send the relevant portion. I'll just go through it and then get back to you,
Okay.
because
How could I
I'll have
send
to
that? I
WhatsApp, on WhatsApp. You are there on the WhatsApp group, right?
yes, I will do.
Yes. You please send that on the WhatsApp group. I'll see. Okay. Another question is: can an accused be a witness himself? It's a very straightforward question. Anyone has gone through CRPC, they can answer.
Yes,
Can an accused be a witness himself?
yes, sir.
Yes. In under which section?
Under 315.
Absolutely. Absolutely. But then, does that uh, does that create any bar? I mean, can that mean that he'll not be taken seriously by the court? Because the accused will obviously say that I have not committed the case. So, in what cases it shall be allowed? Can you narrate the same?
No, sir.
So then, sorry.
Please say. Pratyasha was trying to speak. Please say, unmute and speak.
Yes, sir. So where there is other circumstantial evidence which will help in admitting that evidence.
Right. Right. Of course, there will be. mm, Uh, it has to be corroborated properly in order to make sure that the uh, defense evidence in the form of the witness of the accused is taken into consideration. The Supreme Court has time and again said that you have to take it very seriously, and just because the accused is a witness, you can't just discard it. Uh, the cases where it can be allowed is where in cases of plea of alibi, the accused is actually taking the plea of alibi, then alibi, as they say it. So in that cases, the accused himself has to come and he has to depose that yes, I was not present at this place and I was present at that place. So in that case, or in defamation cases where you are alleging against the accused that you have defamed me, but the accused will say that no, this is the truth. The accused can himself depose, no, this is the truth. So the truth cannot cause defamation. This is another case. So in many cases, the accused can be allowed to be a witness. And another case is, can a warrant trial be conducted in absence of an accused? That is the last question. That is, can a warrant trial be conducted in absence of an accused? Anyone please answer?
No, sir.
No? Sivasis, please say.
No, sir. A warrant trial cannot be conducted in absence of a accused.
In no cases? Anyone wants to? Okay. Anyone wants to differ? Okay. As a general rule, yes, Sivasis, you are right that warrant cases should not be conducted in absence of the accused. But suppose 317 petition has been filed and it has been allowed. So only for a particular date, maybe, because 317 is filed every date, or I mean, it has to be filed each date. And if it is allowed, then only the accused is permitted to not be present in the during the case. So if 317 is allowed, then only he can be permitted not to be present, and still the case will go on. And if it is not, then mandatorily he has to be present during the trial of a warrant case.
Sir, I may differ.
Yes, please.
Sir, I practice in vigilance court at Bhubaneswar. In
Mm-hmm.
most of the vigilance cases are sessions courts, and our honorable High Court granted to allowed 205% to few accused in selective cases.
Right. 205, if it is allowed, that is another thing. That is another thing altogether. That is being allowed by the High Court. That is another thing altogether. So if that are not done, then generally the accused cannot be absent in the court and say that no, I am not present, and still you go ahead with the trial. It cannot be done so. 205, as you're saying, vigilance cases, there must be certain different. What are the grounds the 205 was allowed? Can you please tell me the case?
Like the most of the vigilance cases are documentary in nature, like income, asset, expenditure. You have to prove,
Right.
and you have to prove
Right.
the disproportionate. What is the disproportionate income? Prosecution has to prove. So the presence of accused is not so necessary to prove a documentary case, because the charge sheet has already mentioned the details and all the minute whatever are required in a prosecution case.
Absolutely agreeing that if 205 is
And
allowed in
most of
because it was a
the vigilance
documentary.
cases are sessions case. Sir,
Right.
vigilance case has trial as a ADJ court, which are vigilance court, are sessions court actually.
True.
They
So
can
my
try
question was
the
whether a
case.
warrant case can be tried.
Sir.
So that again also you also answered the question, because a sessions mode is a different procedure altogether, and we actually studied there was this provision of 205 was there. So that apart, taking into consideration the 205 and 317, in no other cases the accused can be allowed to be present, and in specifically warrant cases only 317 are the I mean is the only way to disallow the accused from not being present in the court and still go ahead with the trial.
Sir, exactly.
Okay.
Thank you.
Thank you. I hope it was a good session for all of you. We'll catch up again soon. Thank you all.
Sir?
Thank you so
Hello.
much, sir.
Yes.
Sir,
Anyone?
I have a question, sir.
Yes, please ask.
Sir, you said that the previous conviction cannot be raised before conviction. Means it can only be raised after conviction. But
Right.
sir, I think sir, section 54 of Evidence Act says that sir, exception to the section 54, the previous bad character, sir, maybe is
Relevant.
relevant
That
to sir.
I'm not actually saying that. I'm saying on the hearing, when you are actually, because a charge has been framed, uh, saying that you have been previously convicted, in what cases this is relevant while hearing the sentence? Because there are many cases where it has been absolutely prescribed that on subsequent conviction the punishment shall be this. So in these cases only we are taking into consideration the fact of previous conviction while awarding the sentence. I was when I mentioned that previous conviction cannot be taken into consideration. Of course, you can allege that he is a bad character. Of course, it is a 354 case, and you allege that this person is habitually seen in front of ladies' hostel. So this kind of allegations is very well relevant. But then why what am I saying is that during the acquittal or conviction, when it is being done, you are actually prescribing sentence, and here previous conviction is relevant only to increase the sentence or decrease the sentence, whatever the case may be. That is the reason this previous conviction cannot be raised until the conviction in the present case has been established.
Sir.
I hope you got the point.
Yes, sir.
Okay.
Thank you, sir.
Thank you. Anyone has doubts, or we shall end this? It's almost 1.5 hours, I think. Yeah. Okay, we're ending it. Thank you all. Stay safe. Take your vaccinations as soon as possible, and we'll catch up soon. Bye bye.